This is Brent Allan Winters. This is commonlawyer.com, and we continue today with part 14 in a series discussing whether or not our Constitution of the United States comports with the Bible, is harmonious with the Bible, and if not, where is it not harmonious? There are a couple things we might want to say at the outset that, as many things we're saying here, bear repeating over and over and over, including definitions of words, but there is a movement afoot in the United States to scuttle our Constitution. Some well-meaning people look about us and are discouraged, as are many, maybe even most Americans are today. Obviously, we in America are being railroaded toward an increasingly intense police state, where force is the only means of government. Two groups here, antagonistic to one another, as there are always. There are those who love freedom and want to work and produce and take dominion over our land and cause it, to the glory of God, to produce its raw resources, and to take those and use them to our benefit and God's glory. There is that other group, I like to call them, and this is an accurate description of the evil empire, who seek to do only one thing: not dominate the earth. They seek to dominate other men, and they see that the greatest opportunity for that is to infiltrate and subvert government, because in government there is the possibility of enforcement, and there are the levers of raw power: military power and police power, guns and cages, falsely glorified as correctional institutions and prisons. They are nothing but cages, sometimes called jails. Well, those that have the desire in their wills to do as God would have them do are frustrated, and not understanding the difference between our Constitution as against civil law codes, and looking for a way to change things, say that we must rid ourselves of this Constitution. It's never worked right anyway, therefore it's time to get rid of it. I might add, some of the people that want to do that come from backgrounds, religious backgrounds, that inculcate in their adherents obedience to commands from a single will, whether it be a dictator, a pope, or a bishop, or some other so-called religious leader that practices priestcraft, whether or not he or she wears the garb and the trinkets of priestcraft. But they seek clarity. They say there's something wrong. Our Constitution isn't straightforward enough. It allows for too much confusion in their minds and messiness. In fact, it offers three co-equal branches of government without clear order between them. None of those co-equal branches able to give a final word on anything. They seek precision from an ultimate lawgiver, precision that would rob them of their God-given duty of discernment, using the law of God as it is written in the Word of God and as it is revealed in the creation of God. Some of these have even gone so far as to compare our Constitution to the Talmud, and in so doing lump them all together as that evil system that the Lord Jesus Christ denounced with such strong language in the Gospels, in those days called the tradition of the elders. The tradition of the elders was Babylonian Judaism, and in those days it was called the tradition of the elders. Whether or not it was written down, as it is today in the Talmud, we're not sure. But in any rate, it was, as all Talmudists today affirm for us, it was the tradition of the elders of Jesus Christ's day, was Pharisaism. And Pharisaism is the political party that was powerful at that time, and the Talmud arose out of Pharisaism. At any rate, these persons that are frustrated and want to do what God wants and want the government of God to prevail have said that our Constitution was a bad idea to start with. Well, our Constitution is wholly incomparable to something like the Talmud. The Talmud, from start to finish, is hypothetical at heart. Our Constitution demands real cases and controversies and recognizes, since it is a common law document, an expression of common law government. It recognizes that our common law, the law of nature, can only be known in its application, never in hypotheticals, and it goes so far as supporting our common law tradition that that no issue may government be involved in deciding unless it is a real issue, a real case in controversy with a real, as it were, bloody plaintiff. And beyond that, the Talmud talks about everything. It doesn't just talk about limiting government. Matter of fact, it doesn't do that well either. So there is no comparison between the two. Also, these that say our Constitution needs to be done away with once and for all fail to acknowledge that our Constitution is about limiting government wholly, and it is not about limiting men, because in a country that is a common law country, where law and standards of law are silent, men are free to act. That is not true in the rest of the world. Men feel compelled at every point to check with government to see if they can or can't do something. Indeed, men are free to establish relationships of contract, of trust, and to define those relationships, how much discretion is to be given to each party in those relationships. In a civil law country, that is not the case, and any claims to the contrary, and I might add, most civil law countries make claims to the contrary in their law. Such claims are not real, just as some Roman civil law countries now claim to have juries, but in doing so, they provide an ultimate judge to set as a final check upon the decision of the jury. So in that sense, it is not a jury at all. Most of what is done in civil law countries is window dressing to keep the masses happy and thinking they have some modicum of freedom, when indeed they do not. A distinction that ought to be made, to take another point, is the distinction between a theocracy and what some have called an ecclesiocracy. Ecclesia is a fancy Greek word for church. The ecclesia of the New Testament is often translated church. It is a word lifted out of the Greek language and impressed to a new use in Christianity. Be that as it may, we can go on and talk about the difference between a theocracy and ecclesiocracy, or a theocracy and a churchocracy. It is true that all governments among men are theocracies, whether men admit it or understand it. Now, some are clearly theocracies and say so. Islam says that they are government by Allah. Indeed, the word Islam means obedience, and an Islamic adherent claims to be worshiping through his obedience Allah, because Allah, so he says, has communicated to his chief prophet Muhammad. To further confuse matters, the second greatest prophet in Islam is Jesus Christ. But Islam refuses to acknowledge that Jesus Christ is God, reduced to a span, that is, in human flesh. Other proclaimed theocracies have existed in the past. The Holy Roman Empire, for example, which held sway in much of Europe back 1,000 years ago or better, claimed to be ruled by God through his vicar, which is the Latin word for the Greek word anti. The vicar of Christ claimed to come along and take the place of Christ on earth, and along with the Holy Roman Emperor, such as a man, for example, Karl the Great, fashioned and made into Charlemagne, was his helper. Well, they made no bones about it in those days. That was a theocracy, indirect rule by God. But when we say that all governments on earth are theocracies, theo, by the way, is the Greek word for God from the New Testament, and kratos and krasi means Greek word meaning to judge or to rule, more explicitly, is God rule, theocracy. All governments are theocracies in this sense. All governments rest upon a certain standard or a certain law expressed somehow. And law must come from a giver of law, called anciently lawgiver. And anciently, and until even modern times, a lawgiver is defined as that person or bevy of persons who, by a single will, decides finally, without appeal, what is right and what is wrong in any particular circumstance. It is in this sense that the psalmist says of the judges of Israel, "Ye are gods, Elohim." And Jesus quotes that passage written by his ancestor, King David, to make the point that the law of God was applied finally and without appeal through the judges of Israel, which also amounted to juries. But that lawgiver, that one from whose decision there is no appeal, is called a God. That has been ever so before the scriptures were written, through that time and up until now. Because any will, any person that has that power over a man or woman to decide for that man or woman, finally and without appeal, right from wrong, clearly rules over that man or woman, finally and ultimately. And such a person is a god, whether it be a demon, whether it be imaginary, whether it be the God of all creation of the Bible, whether it be the Pope of Rome, or some prophet that some group declares to be God. Maybe people who believe the Supreme Court of the United States has that power to decide for them what is right and wrong. Whether or not, for example, they have the lawful right to murder their own children through abortion. Well, if you believe that the Supreme Court of the United States has that right to dictate for you right and wrong in that ultimate question, then you have chosen your God. So it is said, "Show me your lawgiver, and I will show you your God." So in that sense, all governments on earth are theocracies. That is, ruled by some God, named or unnamed. But, of course, when people say that they're against a theocracy, they usually mean the Christian God. We don't want a theocracy. Well, that's a bad way to say it. I want God to be the God of my life, the God of the Bible. And I crave His standards above all other standards. And I identify with Paul the Apostle when he says, "The things I want to do, I don't do. And the things that I don't want to do, I do. I want to do right, but sin resides in my members and I struggle against it. So I desire the law of God because I believe that it is quick and powerful and sharper than a two-edged sword, and that it has the power, when wielded by the Holy Spirit in my body, as it is, that I can do the things that please God by faith, and manifest His ultimate love. This is the love of God," said John, "that we keep His commandments." Well, that's what theocracy is. All governments are theocracy. All governments rest on law, and all law comes from a lawgiver, a final arbiter of right and wrong in another person's life, and a lawgiver is a God. Show me your lawgiver, I'll show you your God. Now, we shouldn't be against theocracy. In that sense, we should be for the idea that God, who is sovereign above His creation, rules all things however He does it, and He does it in mysterious ways. But when people say theocracy, what they generally mean is rule directly by God. But what they are really afraid of is ecclesiocracy. Not rule directly by God, but rule through an organization of a church's rule of a country. Now, I didn't say the true church's rule. Even if you had the true church's rule, it would be ruled, again, by men. It would be a government of men on earth. And I put no faith in the arm or the flesh of any man, regardless of his religious claims, because the Bible tells me not to. And for that reason, our national motto is a good one. In God we trust. Because the implication of that is we don't trust men. I don't want an ecclesiocracy in America, unless the Messiah Himself establishes one, which He promises to do later. He's not here right now. He is bodily removed. His spirit is here. But He Himself resides in heaven at the right hand of the Father, so the Bible tells us. And that doesn't mean in spirit only. That means in body, in flesh and bone. He is in the courtroom of heaven, forever making intercession for our misdeeds. So, to recap, we distinguish between a theocracy, which is a rule by God, and an ecclesiocracy, which is a rule by some organization calling themselves the church. In truth, the Holy Roman Empire was nothing more than an ecclesiocracy, and the Pope of Rome still claims that he has the right to exercise that ecclesiocracy over the entire face of the earth and all that dwell therein. I don't want that. I don't want any church organization claiming that they have the right to rule my life, or the lives of anyone else in my country. As John Wycliffe said to Parliament back in the 1300s, "There is but one mediator between God and man." He was just quoting the Bible, and we can do the same thing and go straight to the original source. It says there is one mediator between God and man. Wycliffe continued, though. He said, "There is no king, no parliament, no pope, no church that can rightfully be interposed," watch me close, "between the individual and his God. And anyone claiming they have the right to do that, or any organization claiming they have the right to do that, is Antichrist." Well, some would say that our Constitution is imposed between us and God, because it says in Article 6 that it is the supreme law of the land. Well, again, this is something that needs to be repeated often. Number one, the word supreme, as used there, is a comparative, not a superlative. Compared to what? Compared to the laws of the states. And it doesn't say that if the law of the federal government and the laws of the states is different, that the Constitution trumps the laws of the states. No, it doesn't say that. It says if they're contrary contrary. What does that mean? That means if you can't follow both laws at the same time. And there are a lot of laws that the federal government has passed, not to mention, of course, our Constitution. There are a lot of things in the Constitution that we can follow, that we can adhere to, and that we can actually, we're not following them, we're insisting that the government be limited by the provisions of the Constitution, and at the same time follow the laws of our respective states where we live. The word there is, it's supreme, that means with relation to the state laws, where the two are contrary. Key word being contrary. Some say repugnant is a good word. It is not. It's too weak. It means merely distasteful or offensive. Well, there are a lot of laws that the states pass that are offensive to the laws of the federal government. That's not enough. The laws have to be contrary. That means they have to, watch this word, contradict. And in application, that means, again, that both can't be obeyed at the same time. By the way, that's the same standard that should be applied to any laws of men respecting the law of God. The laws of men should be followed, as long as those laws do not stop a person from following the law of God, even if they seem distasteful or even ridiculous. But we hasten to add, there are those standards that government puts out that prevent a person from obeying God. And such a thing happened in Acts chapter 4, where the apostles there, two of them, were forced, they said, to choose. They could not do both what the Pharisees said in the Sanhedrin and do what God said. And so they asked, shall we obey you or obey God? If we could do both at the same time, then that's all right. But in this case, we can't. To do the one is to disobey the other. But to take issue with the word repugnant, Justice Marshall used that in Marbury versus Madison. And the word's okay. I just don't think it's as good as contrary, because contrary is the word that the Constitution itself uses, and it's more definitive. It makes the point clear. By the way, Marbury versus Madison is complained about because it is said that Marbury versus Madison gave the Supreme Court supreme power over all other branches of government. I don't read it that way. I don't know where people get that exactly. Even if the Supreme Court said that, that doesn't make it true. But they didn't really say that. What they said was the Supreme Court said that they have not the right necessarily. It is a right. It's a jurisdiction. They have the jurisdiction to review everything that the federal government does, all acts of Congress, and to deliver an opinion. They have a responsibility to tell in writing what they think, whether they believe it's constitutional or unconstitutional. And that's usually what they do today. But remember this, it's not called an opinion for nothing. The decisions of our Supreme Court are not called commands. They're traditionally called opinions because the courts deliver opinions, and they also print their dissenting opinions, which, by the way, in civil law countries is not part of what they do. They don't allow dissent. And they don't publish it, because if they do, it'll make the government look like it's not a monolithic solidarity and not a single will. In America, we know our government is not always a single will, and we've grown comfortable with that idea and the apparent unsurety of it. Why? Because we're used to here, God help us, we're losing it, we're used to making our own decisions. The court can think what they think, the president can think what he thinks and do what he thinks. If I think I'm right, I'm right. I've got to answer before God. I can't take refuge in the Supreme Court of the United States or the President of the United States and say, well, they said it was okay, or the Congress of the United States. Well, the courts in our country, because we're a common law country, deliver opinions, not commands. And they tell us what they believe about things, and we observe that they're often wrong and even sometimes admit it. And even when they don't admit it, sometimes they just slowly change their position over time. But Marbury versus Madison stands for the proposition that the Supreme Court has, and the Constitution says it this way, the responsibility to review cases in their discretion. Well, that's a common law standard. You know, it's of great note also that there's nothing in our statutory law that says how to determine the Supreme Court's final opinion. By tradition, we do it point by point, not opinion by opinion, but point by point, attributing the court's opinion to a majority. In other words, 5 justices. And that's down to the details, by the way. In some opinions, 5 justices may go one way on one point, point, and on some other fine point they may go another, and it may be that they've written so much you can't discern which is which. And in such cases, that creates confusion for the lower courts. Sometimes the judges in the lower courts don't even pay any attention to the Supreme Court. Why, I've heard U.S. attorneys get in front of the federal appellate courts and say, we know the Supreme Court says that, but the Supreme Court was just flat wrong. But if they believe the Supreme Court is wrong, I suppose there's nothing in our tradition that says they shouldn't say so. But when I heard it was said more than forthrightly, it was said arrogantly. And so that's why I object to their attitude. Well, to continue, this movement afoot to get rid of our Constitution is a movement to rid ourselves of common law government. And if that ever happens, it is happening by inches now, and it's come a long way. If that happens, we lose our freedom. And by the way, that is why we're losing our freedom, because our common law is the laws of nature. And the laws of nature are the laws of nature's God written in his creation. Well, let me start where I left off. I got sidetracked again. It wasn't your fault, obviously. But in America after the Revolution, the common law prevailed over the prejudice of all things English, which for a time threatened a reception of French law in America, which is the Roman civil law, the city law, the law of the city as opposed to the law of the land. And Americans were prejudiced against everything that they perceived to be English because of what had happened and what the English had tried to do to us here in America. And they developed a doctrine that was nothing more than the civil law doctrine that is antagonistic to our common law due process at every point. This movement became organized, and so much so, just as they've done today with many controversial questions, such as environmentalism and women's rights, so-called. They took their cause when they couldn't get anything done at the constitutional level. They took their cause state by state to the state legislatures to try to rid ourselves of our common law. In the state of Missouri, it was prevented by one vote. That was back in the early 1800s. In the state of Kentucky, it was prevented by one vote in the legislature thanks to the efforts of Henry Clay. Well, the hard feelings between America and England persisted for a few decades, and they lingered and gnawed at the craw of Americans. The animosity grew, and it grew until it fomented again in war in the year 1812 during the presidency of James Madison. It was fueled, no doubt, by English arrogance, which translated into disrespect and contempt. And part of Henry Clay's efforts, besides what he did back in his home state in Kentucky, part of his efforts to assuage this injury to American honor was to talk Congress into war, to stop England from what they were doing on the high seas to Americans and in hampering our trade with other countries, as they had done before the American Revolution. England answered, invading the United States, burning our capital, and landing down in New Orleans to try to take over the West, the whole Mississippi Valley. And after those atrocities, American antipathy for England grew deeper and deeper and deeper, until it became a popular political mania, and it reared up into a fright-filled foreboding of all things English, most of all English common law. Americans were persuaded by forces then evil that had infiltrated and saw political opportunity to exacerbate a wound and enslave our country, much as Germany before World War II, who saw political opportunity to exacerbate a wound that was centuries old against Judaism and work the country into a frenzy. Well, as American dislike for her inherited common law customs and traditions swelled, revolutionary activists worked loathing of the common law into scorn and then panic, festering hatred of common lawyers, upon whom the blame of all things wrong in America finally fell. Now remember, in all this, our Constitution is a document, a restatement of common law government. And to aggravate circumstances further, after the year 1800, the Napoleonic Wars cut off the American states from foreign trade, reducing their commerce to a trickle. Little commerce meant little litigation in common law courts, and consequently little need for common lawyers. And by the time of the War of 1812 with Britain, Americans saw the common law and common lawyers as not only useless but dangerous. Thinking the times were ripe at this point, the anti-common law, that is the pro-city law people, the faction, moved to supplant our common law tradition by persuading the American states legislatures to enact the civil law in a form akin to the French Code of Napoleon, such as Louisiana had enacted in 1825. Kentucky and Pennsylvania were caught up in the mania and forbade, listen to this, they actually forbade lawyers to cite English court cases in their courts. Kentucky introduced legislation to repeal her common law. I might drop a footnote here. To forbid American lawyers from quoting English cases would have taken our freedoms from us. Whatever may be said about England, and of course we didn't have much good to say when they were trying to kill us and we were trying to kill them. Nonetheless, God works in strange and mysterious ways. Their common law was the reason for that war. We wanted their common law and they wouldn't allow us its freedoms. The American Revolution was about the freedoms of the common law. And to not quote common law in our courts would be to deny things, for example, that are the common law foundation of our Fourth Amendment, for example. The well-known Castle Doctrine of England. It's often quoted, for example, the statement of the Prime Minister of England in Parliament when he said the poorest man may in his cottage bid all defiance to the crown. The rain may enter, the wind may shake it, the storm may enter, the wind may enter, but, says he, the King of England cannot enter. All his force dare not cross the threshold of the ruined tenement. Well, that right there was the common law doctrine that began the birth of the baby of America, when James Otis argued against what King and Parliament called the writs of assistance that did away with the Castle Doctrine in America, saying, as did William Blackstone, the common law does not apply in our American plantations. Plantation is an old word meaning the place where we have planted colonies. You see, some states, matter of fact, probably most states, I haven't looked at the laws of all of them, but for example, Illinois became a state in the year 1818, part of the Northwest Territories, 2 years after Indiana, and a couple of years before Missouri, just on the other side. Well, when Illinois became a state, it declared that the common law as it existed in the 4th year of King James I is the law of this state, and it says anywhere where the statutes of this state do not speak. And as far as I know, that's still true in the state of Illinois as it is in most states, although I read recently that Utah has repealed such provision from her law. And in the case where Illinois says common law as it stood in the 4th year of James I, what they meant by that was the year 1607, because 1607 was the 4th year of the reign of James I, and that was the year the first colony was established that claimed jurisdiction over much of what is now Illinois. The Jamestown settlement in Virginia claimed Virginia, naming it after the Virgin Queen, and Virginia at that time encompassed the lower half of what is now the state of Illinois. So in the year 1607, the common law was established over, or rather in and among the people, anyone who would be residing in the lower half of the state of Illinois. The boundaries of Virginia extended westward to the Mississippi River. Well, just as 3 examples, Pennsylvania, Kentucky, and Missouri just dodged repealing all common law standards. What would that have meant? That would have meant they would have gotten rid of all common law due process. One case of this animosity towards the English that fomented a near-violent confrontation in southern Illinois is worthy of note, and we'll quit with this. But these are examples of what's going on today, and we hope that our common law prevails as it always has in the past. But in 1824, English settlers moved the county seat of Edwards County, Illinois from Palmyra on the Wabash River to the English settlement of Albion. Albion, by the way, was named by those English settlers, and it is the ancient name of affection for the Isle of Britain, Albion, given by the Angles and the Saxons, and the Romans used that name for the island. But the militia of Albion, Illinois, which was an armed group of men of English descent that had settled there, and the militia of Mount Carmel, Illinois, a town on the Wabash River near Palmyra, met between the two towns because the records from the county seat in Palmyra were hijacked and moved to Albion. The Albion settlers came from England, and they were looked upon with disdain by the locals because many of the people, the pioneers that had settled nearby there, were American, and to make matters worse, many of them were veterans of the War of 1812. Their animosity toward all things English, including the English people, ran high, and they were afraid that English immigrants would try to take over the country and reclaim it for England. But the Anglophobia that occurred there is of note to reveal what happened in America back in the 1820s and 1830s and the mania that was then afoot to rid America of our common law. The settlers down there along the Wabash River wanted to move the county seat from Albion, where it had been relocated due to political manipulation, back to their own hometown. And the reasons for that were this. First, the English settlers had named their home Albion, an Englishman's ancient and affectionate name for his country, England. Well, that didn't set well with them. Second, a Morris Burbeck, one of the leading founders of the town of Albion, had received an appointment as Illinois Secretary of State from his old London acquaintance, then Illinois Governor Edward Coles, and it appears colluded with this old friend to get the county seat moved to Albion. Third, Burbeck and Coles were both passionate abolitionists, and they were set on making the Illinois Territory a free, that means a non-slave, state. Fourth, Burbeck was an ardent Quaker, and in many jurisdictions he was deemed an incompetent witness and office holder because Quakers refused to swear to tell the truth, and they refused to serve in the called-out militia of the state. Well, the leaders of the English settlement at Albion had misjudged the Illinois settlers, the Americans that had settled about them. Most were native Kentuckians, most were pro-slavery, many were veterans of the War of 1812 with England. In short, the American settlers nearby the English settlement viewed the English with a wary eye, if not hostility. Well, the short of the long of it is that militias from the two communities went after each other and met halfway between the two towns. They parleyed before they engaged in any sort of battle and decided on a settlement, and they divided the county in half. Wabash County against the Wabash River on the east and Edwards County on the west. Well, incidents like this were happening all over the Northwest Territories and the upper part of the South as English settlers moved in. And the reason, above any other reason, that Justice Joseph Story wrote his commentaries on the Constitution that have become so well known was in favor of the common law. As a matter of fact, Justice Story campaigned for our common law freedoms, where he taught at Harvard for a short time at the law school. And some of his young disciples went into the wilderness, into the Northwest Territories, and established Western Case Reserve School, which is still there, in Cincinnati, in an effort to establish our common law in the Northwest Territories, knowing that if the vacuum wasn't filled, that the only other available option, the city law of Babylon in some of its form, whether it be the French Code or some other more objectionable form, would be established in the western parts and the frontiers of the United States. The story of the establishment of our common law in the western frontiers, beginning just as men were crossing the Alleghenies and going all the way to California, is, in my opinion, the most fascinating stories in the history of mankind, and it ranks right up there with any other you can possibly imagine. And the struggle between the law of Babylon and the law of nature and of nature's God tells the story of the history of humanity. Now, in my own humble way, I've tried to record what I believe are the high points of that story in the book Excellence of the Common Law, beginning back at Babylon, where the Babylonian law and its precepts, though they existed before then, they were first organized into what we would now call a system, and where the first emperor finally gained power and could be called of his own right a true emperor, a one-man show. And the story of the United States is no less that story. The struggle between the law of the city and the law of the land, and it rages ever more as viciously now and active as it ever has. You only have two choices. Which one shall you choose? There is no middle ground. There are only two options, the right one and the wrong one under many different labels. The laws of nature unwritten and the laws of nature's God written are the right choice. Those express themselves in the law of the land as opposed to the law of the city. The one is a law of process, not a law of result. The law of the city is a law that must achieve the result commanded. God's way is follow his process. Matthew chapter 18, and when you do so, whatever bound on earth is bound in heaven. God will back you up. That's what that means. This is commonlawyer.com, and this is part 14 in a series on whether or not our Constitution is biblical. And next time, Lord willing, we'll start with part 15.